the Maine rental agreement. In this video, we will tell you about the most noteworthy aspects of rental agreements in the state of Maine. What is a rental agreement? A rental agreement or a lease is a document that outlines the arrangement between two parties regarding a property rental. The one who's paying rent is called a tenant, while the owner of the property, who lets the other party use it under certain conditions, is called a landlord. The parties may also be called a lessor and lessee. Typically, a rental agreement lasts for 6 or 12 months, with rent being paid every month or every week. There is one federal disclosure that works for all lease agreements in the United States. This is called the lead disclosure, and it requires the landlord to tell the tenant about all known lead paint hazards. They should also provide the state-approved version of the pamphlet, Protect Your Family from Lead in Your Home. However, this requirement applies to not all types of residential dwellings. Required disclosures. Apart from the above-mentioned disclosure, the landlord should also provide a potential tenant with a smoking policy disclosure regarding the allowance or prohibition of smoking on the premises. In addition, the landlord is responsible for disclosing to a prospective tenant if an adjacent unit or units are currently infested with or are being treated for bed bugs, and if the current unit was inspected for a bed bug infestation. Another responsibility of the landlord is informing the tenant about the results of the test for the presence of radon in the air, if the building conducted within 12 months of the occupancy of the building by the tenant. The landlord should also provide the tenant who pays for utilities with information about the energy efficiency of the property. One more state-specific disclosure is informing the tenant about charging for late fees. Such a fee should not exceed 4% of 1 month's rent. Security deposits. According to the Maine probate code, the maximum security deposit cannot be more than 2 months' rent. The landlord should return the security deposit within 30 days after the termination of the tenancy, or the time stated in the written rental agreement. For tenancy at will, which is an agreement without a set end date, it should be returned within 21 days after the termination of the tenancy, or the surrender and acceptance of the premises, whichever occurs later. The landlord can use the deposit to repair any property damages caused by the tenant using the damage listing signed by the tenant at the termination of the occupancy. If the landlord fails to return the security deposit, they cannot withhold any portion of the security deposit. Landlord access. According to the Maine probate code, the landlord should give a reasonable notice before entering the apartment to inspect it, do necessary repairs, etc. 24 hours is presumed to be a reasonable notice in the absence of evidence to the contrary. Entering without a notice is allowed only in case of an emergency or according to a court order. Termination of agreement. Tenancies at will must be terminated by either party by a minimum of 30 days' notice. In certain cases, the tenancy may be terminated upon 7 days' written notice by the landlord, for example for non-payment of rent, damages, nuisance, or criminal activity. The tenant, in their turn, may give a 7-day notice if the landlord has substantially breached a provision of the lease.